turn to the fourth case on this morning's docket. That is 106166, State of Kansas v. Stephen Williams.
May it please the Court, Rachel Pickering of the Appellate Defender Office on behalf of Stephen Williams, Chief Justice Nuss, if you could please reserve 2 minutes rebuttal time.
2 minutes is granted.
Thank you. Just a couple quick housekeeping matters. I'm the third attorney on this case. Mr. Edge wrote the brief. Ms. Hughes responded to the show cause, and I filed a 609 letter and a response to State 609 letter, and the State has filed its own 609 letter. So I hope not to confuse all those different filings in today's argument. There's only one issue presented in Mr. Williams' case, and that is something that this Court heard back in October 2011, which is a catechol constitutional challenge. But we have a different offense here, and we're going to argue that that is what changes the basis. The two cases I'm referring to are Cameron and Mossman.
Before we get there, let's talk about procedure. And I know you didn't write the brief, so you don't have to be defensive about this. But I kind of need to know what we do with this thing, because in the defendant's opening brief, you don't tell us that the Eighth Amendment issue was not raised to the trial court.
Okay.
And you didn't comply either with Rule 6.02 by saying that there's an exception that applies for looking at this issue on the first time on appeal. And then to kind of make matters worse, the State points out the error in its brief, and then there's no response back to that procedural question. And then 2 weeks before oral argument, we get a 609 letter where you know you can't raise, and you did that one, but I know you're trying to cover some tracks here. But in all seriousness, what do we do about this? I mean, we've got rules, and do we just ignore them and let defendants raise, or let parties raise issues improperly to the court?
Okay.
Why isn't the preservation argument that the State makes good under these facts?
Under these facts, it depends on how you want to take a look at the exceptions. Those three exceptions, does this court apply them sua sponte? Well, the defendant didn't respond, but we see that there were three exceptions.
But don't you waive the ability to raise those exceptions when you don't mention them? Isn't that what the rule says? I
don't know if you waive it.
An argument not made is waived.
Right. I don't know if that's I wouldn't know if I would categorize it as a separate argument that the defendant has to first raise in his brief preservation.
No, but don't you have to tell us that you're raising it for the first time on appeal, correct?
Correct.
You have to do that. You didn't do it.
Right.
It wasn't done.
Right.
Let me reword that. I'm not trying to get on you.
I'm trying to figure out. Question.
This is a real fork in the road, I think, because, in some cases you get it raised, not raised, but, in this case, the other party in the litigation has pointed out the problem. Then you get no reply back, and it really seems like we just have to ignore the rules in order to proceed to consider this Eighth Amendment issue.
Well, it depends on how strict you want to be on ignoring the rules or applying the rules, because 2 weeks before argument, I did respond and caught it. And so do we apply that rule that it wasn't, the preservation issue wasn't addressed at a reply brief, or do you wait until we're here at oral argument, you have documents filed, and then you say, well, they actually did address it. not at oral argument, but in a 609 letter, they point out that this is a legal question. And so that would be one consideration that this court has to grapple with. I'm not really giving you an answer.
No,
But it's interesting
I don't know
because...
that there is an answer. But we got to come up with one.
Yes.
Because we have to answer his argument
Well, I
that
could...
you guys didn't do it and you were supposed to.
Yes, well...
So we got to say, never mind, to the other side, or we have to say something.
Well, or it
We're
could
gonna
be this error was caught and appellate counsel addressed that in a 609 letter. That could be one, which allows me to get to the issue.
And 609 letters can raise
No, they
brand new
cannot.
issues.
They
Okay.
cannot. We already have that law. Justice Nuss has a case, I want to say it's Houston, where the defendant tried to raise a new issue in a 609 letter, and this court said, you cannot do that. So if 609 letter isn't the way, can we address it at oral argument? Because, and that's another question, is when can the appellant address the preservation?
We're not really, are you raising a new issue, or are you responding to a new issue raised by the state? Because a reply brief is improper unless the appellee raises a new issue.
Right, new material is what the rule says. So, reply briefs, we have 14 days to get a reply brief filed. We can get an extension if we want one. And so that is an avenue to take. I guess I would argue take the most lenient approach, which is it is being addressed, it is being sought, it is not a new issue, it is addressing the state's response. Do courts review reply briefs? Yes, in this case they would have reviewed the reply brief to address it. And I understand this court's concerns. So
we apply the rule of lenity.
to appellate counsel, what's good for one counsel is not, well, it depends. I mean, how strict do we get on this preservation issue? When can appellate, it's a great question. I mean, I'm sorry, I'm looking at this from just a general practice question of when do appellate counsel, if they've been, poked by the state saying, hey, you did not preserve this, why, I mean, there's a preservation issue, when do they have to respond to it? If they don't do it in a reply brief, can they still respond to an oral argument? Or, like I said, in a 609 letter, or the cases I cited, State v. Mossman, State v. Cameron, the state's cases cited in the state's brief and 609 letter and mine, all deal with this is being raised for the first time and this is a question of law. So the issue of how it can be raised and whether it can be raised is quite solid in terms of Mossman, Cameron coming out July 2012 saying, yes, you can raise this.
I don't remember if in those cases the defendant's or the appellant's brief admitted up front, this wasn't raised below, but here's an exception you can apply.
They did not.
Does that make it, they did not?
They did not, because it was a request by the Supreme Court, this court, to do supplemental briefing.
Supplemental.
And therefore, it was not raised. And I think that's...
So it's a little different situation, because it was post-Graham, so we were trying to figure out how to put Graham into the equation.
Right.
And it was raised as a categorical challenge.
Right, which this is.
And there is some history of our considering categorical challenges for the first time on appeal.
Yes, which you did, in Cameron and Mossman. And the Court of Appeals is doing so as well, below, in other cases. Unpublished, Clay, the case cited, and my 609 letter did reach it. So what do? Do we hold I'm going to get back to your question because do we hold the appellate counsel to 14 days? Because that's your reply brief deadline. And I've had reply brief deadlines, extensions, and if you miscount it, sometimes the court will not let you file a reply brief. This is Court of Appeals. So I have 14 days to address a preservation issue. That's why. That's concerning.
Really the answer, though, there, that in your opening brief you say, hey, we're raising it for the first time. Just do what the rule says. We're raising it for the first time on appeal, and here's why the issue is properly before the court.
Right,
You just follow the rule and you're good.
right. It's like, right should be right after standard of review. The rules say you have to put the standard review in there. Most appellate,
Shouldn't it be before? Shouldn't you have a section like we used to do? You know, issue raised below, or issue
not raised.
raised and also where the issue was dealt with, because that affects your standard of review. It should come
Absolutely.
before the standard of review, and it should be before it on every issue, because it could be different.
It would be before your standard review, okay.
Well, let's move on to the merits, because I don't want all the time to run out on...
I see that. I'm down to 3
on
minutes.
this. So let's go ahead and talk
Okay,
about categorical challenge.
but it's an interesting question. Okay, so we were show caused, we addressed this, that this is not a moot issue. So let's get to the merits, and I want to get to the merits really quickly. I have 3 minutes to do so. How is this case different? Well, we have a couple things. Mossman, you have, unlike Mossman, you have no physical contact. Unlike Cameron, the child was a minor in Cameron. Here we don't have that. What we have is a group of offense where if a 19-year-old receives a picture from his prom date with her top off and she's 17, that fits under the category of offense we have here. This is such the offense, here we have somebody who has child pornography.
But
There's
if he
no
killed
question
her,
about that.
if he killed her, he'd only have 3 years of, if he killed her without,
Right.
if he kills his prom date without premeditation, he has 3 years post-release supervision. But if he gets caught looking at her picture in his own bedroom, and it's a suggestive picture, and he's looking at it for his own gratification, then he does not have another free day the rest of his life.
Not for the rest of his life. He can never vote. He can never hunt. He loses his civil rights, besides being constricted in terms of travel. The other thing is, guess what? Maybe he gets probation. That's how off this sentence is for this crime, is he might not, I'm using he, may not receive post-release whatsoever. He can be put on probation. This is a border box finding. It's a severe level 5. So in one case, you would say, well, the crime fits the punishment. He has pictures of his girlfriend. He should have deleted them off of his phone. He didn't. He gets probation.
This sounds like an
As a
case-specific challenge.
That's what I was thinking.
No, I'm in a categorical analysis, we get to take a look at that offense, right? The offense, this court says, is the the exploitation of a child. Under that category, in Kansas, you get lifetime post-release, maybe. And that's the part. I'm not trying to get case-specific, but I'm trying to point out in Kansas, you can either get 0 or 100. In other states, like the feds, they do impose lifetime post-release, but several states have adopted lifetime post-release, but they can be discharged. Those are different individuals. Those are somebody who you'd see as a rapist or a criminal sodomy. They might not result in life prison, which is what we have here. So I'm trying to show you the stark difference between somebody who has that situation, because we are looking at this broad category of...
Well, the broad category can include fairly egregious sexual exploitation, which possibly could warrant lifetime, I don't know, but that decision's been made that it warrants lifetime post-release. And like Justice Luker said, you're looking at the specific facts of this particular case and saying, no, in this case, it doesn't.
I wasn't trying to look at this case, because this case, you do have facts of a child, child pornography. What I'm trying to say is, as a category of offenses, we do get to consider every single type of scenario. Remember, because the U.S. Supreme Court did that for murderers. There were some aggravating factors in one of the other cases, I'm forgetting the name, and they looked at, no, we're going to look at this just as a class of murderers.
And what is your category that you're claiming your client belongs to?
Well, the category is the crime of the conviction. which Mossman and Cameron has told us, and that is in my 609 letter. The category is sexual exploitation of a child. Now here, he is convicted under A2, which puts somebody who, under the age of consent, could have sexual intercourse at 16 or 17, but if she sends a top...
So it's just anyone, regardless of...
Anyone.
Anyone convicted of this category of crime.
Right. So you have a different recidivism problem that you would have. Now, Justice Rosen, I want to address your problem of what if you have these horrendous cases of somebody with 100 pictures or 1,000 pictures of child pornography. Well, the whole point is for us to show how there is no discrepancy between that person who should be monitored and the person who is 19 with the sex phone picture.
But is that our question in a categorical challenge? Can we look at the least offensive when we're looking at the entire category of offenders? Or is our question, if in that category of offenders this is is not disproportionate, then that answers our question. Not whether one portion of that category is a disproportionate punishment.
I think you have to address that because you can't address the disproportionate. Whether the punishment fits the crime, which is really the disproportionate question you have, I think you do have to address all the ranges that this falls under. Because it would be quite easy for us to point to the person with 1,000 pictures of child committing sex acts and say, well, definitely lifetime, versus the other person who has, knows it's his neighbor and she's sending him pictures. I think we have to address that in order to look at when we compare it with other states. Other states, they've made the victim, they've changed the age of the minors different, and other states allow them to discharge.
The Supreme Court, one could say, did that when it was looking at the category of offender with regard to juveniles, and they can't be subject to life without parole, and they looked at it in terms of Ozzie and Harriet juveniles rather than the 17-and-a-half-year-old hardcore gang member, and said they're different people, that kind of thing. And so they sort of did that average or maybe not the least culpable, but at least didn't look at the most culpable among the group. Did they?
No, they looked at, right.
So I'm not certain, what is the touchstone? If you're going to follow the U.S. Supreme Court's lead on how it sets up its categories, how do we do that?
Well, I'm not going to be cheeky, but I like we were trying to narrow it. When we first had this issue with Cameron Mossman, we were trying to keep it as narrow as possible. Okay? Not to exclude it, not to make it case specific, but to say, look, under these factors. Okay, so you can give the average. You can look at it on the average. I don't have a straightforward answer to that, Justice Johnson, and how you would do that. But you certainly have to consider the other cases. Because it is lifetime post-release. It is a crime that will send a person back in prison. For what? For failing to register. And they already have to register for quite a while.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
May it please the court. Patrick Hurley appears on behalf of the state. There's obviously one issue before the court, and that's the categorical challenge. I want to make a couple quick points. First of all, in U.S. versus Williams, State versus Cameron, and U.S. versus Mossman, the those three cases have essentially come forth and say that there's no national consensus against lifetime post-release supervision, and it's accepted by society. And then the second quick point I want to make is, independent of the community consensus, lifetime post-release has been found to satisfy legitimate penological goals of retribution, rehabilitation, deterrence, and incapacitation. And in particular here, in this particular crime that we're dealing with, a sexually violent crime, with minors are included in the pornography category, and sex offenders have a propensity to strike again.
Do we have any evidence that, and I understand that the sex offenders that actually commit abuse upon a child, we look at it as, or have accepted that they have a high propensity for recidivism, but is there any comparable evidence out there that one who possesses pornography has a propensity to commit sex acts, and that we need to protect the public against them being in their bedroom looking at pornography? I mean, the rationale behind the recidivism is we put them away for a long time to protect society. But where is the same rationale for someone that has viewed pornography?
I just want to be clear on your question. You're asking, is there any evidence of escalation or a tendency toward escalation to actual contact with children as opposed to porn?
Right.
Well, I'm not familiar with a national study or a study by a particular institution or educational institution that has otherwise made those particular findings. But for instance, in this case, I know that I think it's in the alcohol report, the defendant said, I couldn't stop looking at porn, and we do have a 6-year-old victim. And so whether or not there's a connection there, I can't say, but we do have a 6-year-old victim that he raped, and we do know that he had pornography, a substantial amount of pornography that perhaps also included pictures of his victim in that grouping. So the short answer, I can't directly answer your question, but certainly there's a number of cases out there suggest that is the case, if you look at the individual facts.
But we're looking at a category. We're not looking at a case where we have a rape that ends up being pled to exploitation. What we're looking at is someone that has viewed images, electronic images, not having another free day the rest of their life, whereas if they killed the person that's depicted in there without premeditation, they would only have their sentence plus 3 years of post-release, and I'm struggling with the proportionality.
Well, lifetime post-release supervision is aimed at obviously helping the offender to follow the lines of the law. And it's not imprisonment. They're not in prison. I mean, it could be worse. And it also is designed to protect the public. For whatever reason, the legislature has determined that this is a sexually violent crime and has determined that the way to protect the public is to attach this type of supervision.
I know the legislature can define crimes, but they are constrained by the Eighth Amendment. And that's what we're trying to decide here, is if the legislature has gone too far in their definition of a violent sexual offender or violator.
Correct, and the Cameron case is a severity level 5 also, and that was sexual solicitation of a child. And so, there are some, at least from a sentencing standpoint, similarities in the two particular crimes that was already found where a lifetime post-release was appropriate.
In the porn case, a child actually has been victimized.
What's that?
A child actually has been victimized.
Well, and that is
depicted.
That is a significant distinction here, because the children who are depicted in those pictures have been perhaps brutalized in extraordinary ways that perhaps you and I have never been exposed to and never will be on a personal level. And so that is a significant distinction between Cameron and this case here today, is that we do have extraordinary violence, and the victims and the impact on the victims is something that, I'm sure people will continue for decades to struggle to sort out and figure out the extraordinary effect it's having on it. And so if there are no more questions, I would simply ask that you find.
Back, sort of touching on Justice Wiles' questions, is there a difference between a mandatory sentence and a presumptive sentence? I think you raised the issue that this was an appeal of a presumptive sentence, and it seems to me it was an appeal of a mandatory, and that we've made a distinction. We've said that off-grid cases or sentences are not presumptive, because presumptive requires being on the grid. I think I'm asking, aren't we really talking about a mandatory sentence here rather than a presumptive sentence as presumptive is defined?
Yes, Your Honor. Any further questions? Otherwise, Your Honors, I would ask that you find lifetime post-release supervision constitutional. It's not an extreme sentence, and that it meets legitimate penological goals.
Counsel, before you sit down, would you double back and address the preservation issue?
Yes, Your Honor. As originally raised, the issue is that there's a procedure that is set forth by the court, and I would equate this simply to a notice of appeal. You either raise the issue or you don't, and so therefore, in a very simplistic way, the procedure was not followed, and so therefore the appeal should be dismissed. Did I answer your question sufficiently, Your Honor?
Yes, would you address the impact, if any, of the 609 letter on this issue?
Well, I think as the court has recently set forth, the purpose of the 609 letter is not to raise new issues, but simply to identify new case law that has come out that may have an impact on this case, and doing anything else at that point is inconsistent with the procedure set forth by this court for the efficient administration of justice. And so you end up having an endless array of possibilities that can be raised at any time, and it becomes much more challenging for the court and the parties to manage that type of a procedure. And so I would go back and reiterate that the procedure should be followed.
And just to make a point, the 609 letter from the defendant raised or pointed out a 1967 case in its 609 letter on this issue of exception.
Yes, and there was certainly a response that I could have made, and that is inconsistent with the 609 procedure, and so that case was not appropriate. And I could have responded by saying that, but I figured that the 609 rules are pretty straightforward as it relates to it's not a new case.
I know you raised it here. Is it incumbent upon the state to raise the issue of preservation?
You mean just the state? Is the state obligated to make that point?
I mean, if you had not raised an issue that this issue was not preserved, does that waive that as a means of our deciding the case? Well, let me ask you something else.
Okay.
You would agree that preservation is not jurisdictional?
Yes.
Because
agree.
we've got exceptions to preservation, and there are no exceptions to lack of jurisdiction. So it is a separate issue that seems to me that the state has to raise and place before the court.
I think that's an appropriate procedure to be in place, yes, Your Honor.
What is an appropriate procedure? I didn't hear the first part.
I think that it would be appropriate for the state to raise the issue. That's all that I'm saying. He's saying is, should the state raise the issue, and I agree that the state should raise the issue. If it sees the issue, it should raise it.
And if it's not raised below, and it's not raised in the appellant's brief, and the state does not call our attention to that as a preservation issue, and nobody thinks about it till we are here at oral arguments, do you have a position on that?
I think that overall it would be appropriate to be raised, that it would have to be raised by the state. Obviously, if the court were to choose to take a path, and meaning that it can be raised at any time, that's the court's prerogative. But I think that it should be raised by the state in order to be managed or handled appropriately.
All right, thank you. Do we have any further questions of counsel? Any further presentation?
Nothing more.
Thank you, counsel.
My 609 letter. Lastly, this court should consider this under Pierce v. Board of County Commissioners, 1967. See also a 2012 case. So I'd hate to get smacked for citing an earlier case with the idea that I did cite Mossman. Pierce is just the standard one that people always go to. That's why I cited it. It's one that's been cited hundreds of times. Mossman has not. But Syllabus 2 in Mossman does say this is a question of law. Now, this court can consider it, whether the defendant did not raise it or not. I believe that there are 3 exceptions. I think we could harm appellate law, the best it's doing, by not even considering these issues if they don't raise the preservation issue. It is being addressed. I'm addressing it here at oral argument. I addressed it to show there's Mossman that directly hits this point on point. Excuse me, I say Syllabus 2, it's Syllabus 8. I wanted to get that point, and by no means do I mean to misuse the 609 letter. It's a very valuable tool that I'm trying to follow the best I can, filing it 14 days before, filing a response to the state within 7 days, and citing new authority. And so I did cite 2 new authority, which is Mossman, which addresses that.
Can you explain how your client really is impacted by our decision here?
Oh, yeah.
He was convicted of rape also, wasn't he?
Right.
Which is subject to lifetime parole, as I understand it.
Correct.
What's the distinction between lifetime parole and lifetime?
It's a very odd one, but lifetime parole allows you to be discharged from your parole. No, yes, and versus lifetime post-release, if you should violate the post-release, you're sent back to prison for your entire life. So it's actually a harsher penalty, and that's why this court pointed out in State v. Cash that...
I mean that if you're sent back after a parole violation, you can be re-paroled.
Correct.
That's what you're trying to say.
Correct. And I could pull the statute for this court if it needs it. It was listed in Mr. Williams' supplemental briefing to that statute that says that. Unless I'm out of time, so I will simply say a child brutalized in an extraordinary way is child pornography. Child pornography is also receiving a picture of your girlfriend with her top off. That's why we're arguing that this is disproportionate. This is somebody who is legally able to give consent to have sexual intercourse, and yet, should her boyfriend receive that picture, it's a lifetime post-release.
We have any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Clerk will take this matter under advisement. That concludes this morning's docket. The court is in recess until 9 o'clock tomorrow morning.